the title of this lecture is a general description of felony probation in Hawaii. I underline felony probation because the source used for this lecture, which you should read, it's available freely on the web. You should download it and read it prior to viewing this lecture, is felony probation in Hawaii. So it's a study that's just on felony probation in Hawaii. Next slide. All right. Recall that in crude terms, there are two basic types of quote-unquote community corrections. There is probation and parole. And the goal of this lecture is to provide a general description of the felony probation system here in Hawaii. Due to the lack of publications that are specific to parole in Hawaii, I draw upon a report written for the state of Hawaii about felony probation, again by my PhD committee chair, Professor Emeritus Gene Casselman. I make a big deal out of it just because he's a really cool, wonderful person who treats everybody, including students, like real people. And I apologize if the information seems a bit dated, if you will, but the data or information comes from sort of the late 1990s. But I use it because it's the most up-to-date academic publication out there available that's regarding probation specific to Hawaii. So there may have been some programmatic policy or staffing changes that only a person working in the system would know about. But it is the most up-to-date information that's publicly available, and it's relevant here to Hawaii, so I think that it's good to use. I'd like to, again, remind you there's the differences between parole and probation. A sentence of parole arises from an initial felony conviction that first resulted in a prison sentence. So to be on parole, you first have to be convicted of a felony, and then you go to prison, not jail. Generally speaking, a felony sentence carries a sentence of at least a year in a state prison system as opposed to a county jail. And what happens is that you, on parole, you are giving essentially early release from prison, and then you're out in the community under a set of restrictive guidelines. And if you follow them, you never have to go back to prison again. And if you mess up, don't follow the guidelines, you can be sent back to prison. Probation, on the other hand, now it doesn't have to just be for a felony probation. It can be for a charge other than a felony. In fact, the less serious the charge gets, in Hawaii, I won't touch on this. It's violation, petty misdemeanor, misdemeanor, and felony, and there's 3 classes of felonies. So for some lesser crimes, you can get probation. Obviously, the less serious crime is, the more likely you are to have probation, and here's why. Probation essentially means you've been convicted of a crime, and the judge says, or the law tells the judge to say, for this offense, we're not going to lock you up. Instead, we're going to put you on probation. What that means is that you're not going to be incarcerated or locked up, but you're going to live in the community again under a set of restrictions of your probation sentence. Essentially, be a good little citizen, don't commit any crimes, meet with your probation officer or PO, do what she says, and you're free after your probation sentence has been served. Of course, if you violate probation, the court either has the option to continue on probation or, in in other cases, put you in prison. Now, this being said, according to the 2000 report, it says that some felonies, so I said that probation you don't initially get locked up in prison. This being said, according to this report that was published in 2000, some felony probation cases receive a little bit of jail time before they start their sentence of probation. Generally speaking, theoretically what that means is that you're serving less than a year. So they may send them to jail for a little period of time, and then you're placed on probation. So in theory, you'd be sent to jail, not prison, separate facility, for theoretically less than a year. Okay, so just know the differences between the two. Okay, now remember for this lecture, we're going to describe felony probation in Hawaii. Okay, a felony is the most serious type of all criminal offenses. And what a felony means, if you will, is that a convicted felon could receive at least 1 year of prison time. That means this lecture will not cover the less serious crimes of violations, petty misdemeanors, etc., which could receive probation. Okay, this study doesn't look at those types of folks. I would imagine because why would you want to fund a study that looks at essentially people who aren't very criminally involved and aren't very serious and aren't necessarily a risk to public safety? Felonies are crimes that are so serious that we say we're going to send you to prison. Therefore, while we could send you to prison, that's an option generally. And since the most serious type of crime stays in your permanent record, etc., generally speaking, makes sense to look at this only for this study. Just know, though, that you may for lesser sentences other than felonies, probation is certainly a sentencing option. Depends on how the law, again, was written. Okay, the laws of the state of Hawaii provide for sentencing a convicted felony offenders to either probation or prison. If the felon is sentenced to probation, they are assigned a probation officer. PO, we'll use PO for the rest. Remember, there's parole officers who also get PO, are called POs for the same PO, parole officer, probation officer. So I'm going to use the nomenclature of PO for the rest of this lecture, or the abbreviation, excuse me. Okay, so if a person is sentenced to probation, they're assigned a probation officer who works for, as of 2000 anyway, the Adult Probation Division for one of the 4 circuit courts, which are organized by county in Hawaii. And it's under the judiciary branch of the government of the state of Hawaii. Note also that in the parole lecture series, it shows that parole is, generally speaking, organized under the judiciary, but in Hawaii it's unique in that parole in Hawaii is organized under the executive branch. But in this case, probation is organized under the judiciary branch. That is most common. Typically, in most states, you will see also parole under the judiciary branch, but that's not the case for Hawaii. So that's a difference in Hawaii. Probation, let's look at it generally speaking. It is the most widely used criminal sanction in the U.S. It changes slightly from year to year, but around 60% of all those under some form of correctional supervision are serving a sentence of probation. As the report indicates on page 6, probation is sort of a unique criminal sanction as probationers serve their sentences in the community. And let me read to you from page 6. Probation is distinctive amongst the sentencing options for felony crime in that the sanctioning, monitoring, and supervision take place continuously in the same social context that gave rise to the development and the commission of the criminal offenses. That is, while on probation, the offender is, to varying degrees, in contact with his or her family, his or her peers, community, culture, etc. In other felonies, we may split it up, send you to prison or jail, or etc. So just recall that probationers can still be employed because they're out in the community. They can have contact with family. Although, to be fair, as the report says, some do not have viable family contacts or employment opportunities and may have never had a close family relationship or ever really been gainfully employed. But it does allow for that. So as a result of being out in the community, if you think about it, probationers experience a greater level of freedom than any other people in the correction system. And that freedom allows for greater opportunities for both doing good and ill, if you will. There's greater access to drugs, a ton of free time, relatively little monitoring by the probation officer, if you will, the POs. It's not like in prison where you're monitored theoretically 24 hours a day. Now then again, because of that freedom, they also have more opportunity for being integrated into society via jobs, family, church, community groups, and therefore more likely, if you will, they have more of an opportunity to be reformed as well. Also, due to the fact that probationers are living out in the community, paying for their own living expenses, probation is immensely cheaper than incarcerating somebody. It doesn't take a rocket scientist to figure that out. If they live in the community, it's much more expensive than putting them in prison. As noted in the Survival and Parole in Hawaii lecture series, Hawaii spends about $100 million a year in 2006 dollars operating their prison systems, and they're just incarcerating about 3,500 people. So to incarcerate about 3,500 people in 2006, we paid about I think it was a little over $100 million, but just say $100 million. So it doesn't take they don't mention probation costs. I didn't see them in this report. But it doesn't take a rocket scientist to figure out that probation costs far less than prison. Okay? Next slide. Okay. The probation requirements, if you will, are pretty common sense. There are mandatory conditions and what they call discretionary conditions. So the rules of for a sentence of probation are very similar for those for parole, and they're quite commonsensical. So essentially, they're under a court-ordered probation sentence composed of both mandatory conditions, that applies to everybody who's on probation, and then there's discretionary conditions as dictated by the judge. And then here I've given you the mandatory conditions listed for you directly from the court. Pretty commonsensical when you read them. Be a good person. Look at the first one. Don't commit another federal or state crime during the term of probation. Don't commit any more crimes. Report to the probation officer as directed, so maintain your contacts. Maintain within the jurisdiction of the court unless granted permission to leave by a court officer. That may be that, even if you leave the island, you need to get permission, let alone go into the mainland. Notify your PO and chase any change of address or employment, if they're arrested, blah, 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 blah. Now, the discretionary conditions, if you're interested, you could look at Appendix A where they list all of them, but they're much more numerous. And they range from fines to psychological counseling to drug counseling, staying clean and sober, etc. But these discretionary conditions are sort of tailored to the individual, if you will. Okay, revoking probation. Obviously, if the person follows the rules for their time on probation, their sentence of probation, they are free, essentially, after their probation sentence has expired. If they don't follow the rules, their probation can be revoked, which can result in either incarceration or a continuance on probation. Okay? Except in the case of a new felony conviction, not an arrest alone. Violating a single condition of probation does not in itself lead to revocation. So let me say that in plain English, if I can. A felony arrest is the most serious kind of arrest, and serious kind of crime. So just because you're arrested for a felony does not automatically mean that your probation is going to be revoked. If you are convicted of a felony, the law dictates in Hawaii, at least it's 2000, that it is automatically revoked. Okay. So that would mean convictions for all of those conditions. Violating a single one of them does not automatically mean that your probation is going to be revoked. Okay. And when you're revoked, it can, again, either result in incarceration or a continuance on probation. Okay. Now remember, before you think, if they break even one rule, we should send them back to prison. One of the things you have to remember is that if we choose to lock somebody up, the state, meaning the taxpayers, will pay roughly about $30,000 per person per year in incarceration costs, and that's just in 2006 dollars. So, when there's no free lunch, if you will, when you say, I want to make that decision, we should do that. Okay, well then that would mean that the tax burden would grow on the taxpayers. You have to be willing to pay for that. Now, at the point of the study, revocation of probation was extremely complex and quite time-consuming. And when you read the description of the report, you can see that it's obviously quite costly to taxpayers, regardless of whether or not the person is sentenced to prison. When you read the description in the report, you can imagine all of the court costs, the personnel costs, and etc. Obviously, if they decide to revoke probation after all of this process they go through, and they send them to prison or even incarcerate them, it's much more expensive. So that the process itself to decide whether or not to revoke parole is expensive, and then if you do incarcerate them, it adds to that cost. Now, just as a note, remember I say things may have changed since this report. For example, I've heard stories, and I haven't seen this in a report, but I've heard stories of a few judges who are participating in a pilot program where they sort of revoke probation or parole right away with a single sort of anything you violate, we're going to lock you up. And I think what they're trying to do is do sort of like a shock concentration just for a few days kind of a thing. But I have yet to see any formal reports on it. Apparently it's still going on. But as of 2000, if you read on page 6, the report really describes the difficulty and the costliness and the time-consuming process of revoking parole. I'm sorry, probation. So the revocation of probation on page 6, let me read you a quote. Even its ultimate sanction, revocation of probation, is limited. In the event a probation officer, PO, and his or her supervisor concur in the decision that a serious noncompliance exists and to withdraw the probationer from the conditional liberty to which he was sentenced, that's fancy language for should we lock him up. The probation officer must prevail in a due process court hearing before a judge where the person has defense counsel for the probationer, and the PO must depend on the deputy prosecutor, to voice the argument for revocation. The PO, as they say, must invest time preparing the testimony and cross-examination for the defense lawyer, and in the hearing, and be prepared to spend several hours of work time in court. Now, when you see, so it's a pretty lengthy process. It involves a court hearing, where involves due process. Both sides have legal representation. And when you see the caseloads, you can see how when they have so many cases that when you can't just revoke everybody because you have to go through this court process. And we'll see that on the next slide. Okay, I've titled this slide sort of Life as a PO in Hawaii, and I sort of want to explain a little bit about the nuts and bolts about how probation actually works in practice. What the authors did for this report, I should say is they conducted interviews with a very small sample of probation officers in the First Circuit Court, which I assume means the island of Oahu, because I know the people involved in this study, and they do their work on Oahu, and I'm pretty sure Oahu is the First District Court. Anyway, they talked to a small number of POs, if you will. Sort of got a feel for what their job was like. Probationers are typically assigned to a probation officer on the basis of simple rotation. Basically, you just sort of, each one that comes gets to a new person. And it's just done like list-like fashion. And a probationer is required to meet with the PO on the very day they're sentenced, unless they're in jail at the time. And in that case, the PO schedules some sort of meeting and it can occur on a later date. But if you were sentenced to probation in court, then you're supposed to go meet with the PO on that very day. That's supposed to happen. At the first contact, or the first meeting, I'm going to read from page 7 here, just because they say it more eloquently than I do. The PO obtains basic demographic information from the probationer, explains the rules of probation, provides written copies of court orders and other documents, and obtains the probationer's signature. Essentially, that would be sort of the rules. Here's the rules that the judge has sentenced to you, and you sign it so that they have a record that you knew what they were. And then additionally, the PO reviews the draft of the court order probation, paying particular attention to both the general and specific conditions of probation. There are 3 levels of probation supervision. In Hawaii, they call them minimum, moderate, and maximum. The level of probation the level of supervision that a probationer receives is in part determined by what they call a pre-sentencing risk and needs assessment, which is a scale-type pencil and paper test consisting of sort of standardized items that's administering usually for the pre-sentencing investigation. So prior to sentencing, the court does a pre-sentencing investigation interview. And these assessments sort of provide, basically you take this test or do this survey and it plunks out a number and it decides which level of supervision you need. Now obviously the judge can decide to put you in a different level. So they're not bound by this survey instrument, but it's in part used. These assessments provide for a classification level, and they do it twice during the first year of supervision and once each subsequent year. Now, just as the report notes that under the discretion of the PO, though, these classifications can be sort of conducted at any time. So there's a lot of discretion in the process, but just know that there is some rationality to them, and they give them this sort of paper and pencil risk and needs sort of test that gives them a number, and that gives us an idea of what level of supervision they need. Cases classified as the maximum level of supervision are required to report to the supervising PO twice a month. So when you're in the maximum level, you have to report twice a month. Moderate cases, you need to report once a month. And minimum cases, once every 3 months. The report indicates the majority of probationers are classified as either maximum or on moderate cases. So that means most of the people they're meeting with twice a month or once a month. If you look at the caseloads, and the report does, as you can see from reading it, at the time of this report, the caseloads averaged about 180. I believe it was 181, but about 180. But sometimes we're in excess of 250 cases. So think about that for a second. You've got 180, sometimes more than 250 cases. And you got to meet with most of them at least once a month. So they give you an example in the report, and they say they gave one PO's workload. He had a total of 233 contacts for an average work month of 20 to 21 days. Because remember, there's only 5 days in a month. And remember, this is not including any time that would be needed to revoke a probation, like we just talked about. Remember, I said that would take several hours of court time, preparation time, etc. You may spend, 1 or 2 days just trying to do the groundwork to revoke probation. And the report also talks about, spending several hours trying to get somebody into a drug treatment program, etc. So these people have quite a caseload, and in my opinion, it's kind of crazy when you look at it. It's like, how in the heck could anybody do that? And then the report notes that, given these numbers, it's understandable that the vast majority of contacts are held in the PO's office. Essentially, the probationer must visit the PO. And if I had to make 233 contacts a month, I'd want them to come to my office too, because there's no way you could visit that many people in a month with 20 to 21 work days. There's just no way. Okay. They also I call this revocation of process revisited, if you will. They sort of ask the probation officer's perspective from this. Like what are the factors that you use when you decide whether or not to revoke probation? First of all, they need to consider the increased cost to taxpayers if the person would be locked up as a result of revocation of parole. They need to make the decision whether it's worth it in this case to spend this much time because I've got all these other people I need to supervise. But here's a description from page 9 of the report. And I noted this earlier. A single violation of a condition of probation does not necessarily lead to a motion for revocation. A motion for revocation is a fancy way of saying they went to court, because they're about to go to court. If a probationer is willing to work with the PO to be compliant on probation, the PO will often continue to supervise the probation within the community. However, any supervision decisions are weighed against any potential threats to public safety. Now, I'm adding, this is an important part. This is Mike talking, not the report. Your professor. Now, here's the report. If there is a perceived public safety threat, the PO must file a motion for revocation. That's a public safety issue. Due to the workload, time conflicts, and or the need to process said motion internally and take it to the prosecuting attorney, etc., they say about 4 to 6 months of non-reporting may take place before the revocation process begins. So again, just sort of another way to look at how time-consuming and whatnot it is. So the POs do have description on the need to file for probation revocation. And then the POs were, as far as I can tell in the report, they don't say this, but it must be that they were asked their opinions on the most common reasons cited for when you make the decision to revoke probation. They're listed on page 9. They are, number 1, arrest coupled with other violations, general noncompliance coupled with an unwillingness to change. That would sort of mean to me, they're just not following the rules, and then when you confront them, they're just sort of, blowing you off. Continual failure to report and noncompliance with drug and alcohol abuse requirements. Many of the people have as a conditional requirement they need to stay clean and sober, and the way they determine that is they give them a pee test of their urine. Now recall, discretion is taken away from the court and the probation officer in the cases of a new felony conviction, and if there's a perception that these people provide or are a potential threat to the public safety. Okay. Now, if you want every single detail of this process of revocation, read the whole bottom of page 9. But essentially, a court process must decide whether to revoke, and unless a serious crime has been committed, the police don't actively look for the defendant, and they sort of wait to pick up him or her in a traffic stop and arrest, or etc. And again, before you panic about dangerous criminals being on the street, recall there's that public safety concern noted above. If it's a perceived notion, if the person is perceived to have a public threat, the police they revoke probation immediately, and the cops do have to go look for him. Next. Okay. In conclusion, the purpose of this lecture was to generally describe the felony probation system here in Hawaii. Probation is the most popular criminal sanction nationally and here in Hawaii. In Hawaii, the probation system, if you will, is organized under the judiciary branch of government, and there are mandatory and discretionary conditions of probation and a process for revoking revoking probation. So there's a process that must go through. And lastly, the sort of life of a probation officer or a PO is described in much greater detail. So that's the end of this lecture.